Good morning, everyone. Thank you for coming. We're going to go ahead and get started. So we are video conferencing between Carson City and Las Vegas. We do have a phone conference line open, as well as we are projecting over the internet. So those of you on the internet, you're aware that there won't be any live interaction. We do intend to take as many questions as we can today that are relevant to our agenda, but if the phone starts becoming a problem, we will just disconnect the line. So please remember to mute your lines, and then if you want to come in, I will rotate again and give people on the phone an opportunity to ask questions if they need to, but please remember to mute your lines. So I'm Marla McDade-Williams. I'm the Deputy Administrator for the Division of Public and Behavioral Health. We have Chad Westham with us. We also have Steve Gilbert, who is the Program Officer 3 over the Medical Marijuana Cardholder Program. And then down in Las Vegas, we have Joseph Thiele, who has been assisting. So our intention today is to go over the proposed regulations as they were redrafted by the Legislative Counsel Bureau to answer as many questions as we can and work through them. This is not an opportunity for us to take comment about amendments to the regulations. We did have our workshop session. We considered all comments that were made during that time and during the stakeholder sessions and made revisions. We can take your concerns about them, but the only amendments that we will be supporting before the State Board of Health will be technical changes that we need to make. For example, we found one in section 46 where the reference is incorrect to a particular section. We'll correct that in our version when we have our State Board of Health meeting on March 14th. There's another area where there was a change related to a criminal background check that comes back that may exclude someone, where we had indicated the applicant would have the opportunity to clarify that within the 90-day application review period. That language was changed. We're considering now how to address that issue. So we'll have technical issues, but again, would ask for your consideration to not think that this forum is for us to accept amendments. But again, we're trying to offer clarification as much as we can to help you as we continue to move forward. So, is there anybody that would like to make public comment in general before we get started? Again, as we go through this is a dialogue. We will allow you to come up and give whatever comments you want to make related to the agenda topic. But at the beginning, is there anybody that wants to come up and just offer general public comment? Anybody on the phone that wants to offer general public comment? Well, then let's go ahead and get started. I'll turn it over to Mr. Westham.
Good morning, Chad Westham, Bureau Chief over Medical Marijuana. Thank you for coming today. We're going to start with the programmatic update. We've got a lot of activities going on at the division. We're working very hard to fulfill what the NRS requires, and now we have regulations drafted, and we're moving forward to Board of Health adoption, hopefully in March. Now that we have the interim finance committee approval for our positions and the funds necessary to build the program, that is what we're working on. We have 12 state employees that we'll be bringing on board to run the program, specifically the establishment certification program and the inspection program. As far as the cardholder program, Steve Gilbert to my left, he will remain in charge of that for the foreseeable future. We'll have offices in Carson City, and we'll have offices in Las Vegas, and the workstations for those positions have been secured. Let's see. All right, well, just a quick overview on, and I'll ask for questions at the end if I wasn't clear. But you may be asking, what kind of positions will we be using for overseeing the certification of establishments and their inspection? We'll have what we believe will be a program manager 2, health program manager 2 over the medical marijuana establishment program. There'll be a person who specializes in training and communications, assisting them. It'll be another program officer, which will help coordinate between the establishment certification and the cardholder program. There'll be and these positions are still being developed with our Department of Health, Human Resources Management at the state level, but there'll be medical marijuana inspectors and a supervisor. There'll be 3 of those, as well as another kind of inspector that we refer to as an auditor, who will be reviewing financials and inventory and other related matters on site. And those positions are slated to become auditor 2s under the state system. And then there's administrative assistant support both in Las Vegas and Carson City. So overall, between the auditors and the inspector position that's currently being developed, there'll be 6 inspectors, 2 in Carson City and 4 in Las Vegas. Okay, so in addition, when we get to the point in time where we start accepting applications for medical marijuana establishments, we've had a workload analysis performed, and we know that it's going to require more staff, more people to review those applications and rank them than what we have with the state employees. So there'll be temporary staff, temporary professional staff that we'll bring on board. And right now, criteria is being developed so that we know what kind of temporary professional staff would be appropriate for us to bring on board for that process. In addition, we are gearing up and preparing for the establishment application process. We're creating forms and notices for the time when we announce that we're going to start receiving applications in 45 days. The forms that will make up the establishment application that applicants will submit, those are all being developed now. They're not ready for higher level or legal review yet, but we're making good progress. And let's see, also we will be posting for applicants' benefit a frequently asked questions section on our webpage. There already is one, but we'll be enhancing it with questions that we get in forms like this about the applications, about the regulations as they pertain to establishment applications. And so we feel like that'll be helpful for those wanting to apply. We're getting a bit of feedback on the phone. If you could please mute your phone when you're not speaking, we'd appreciate it. Okay, so again, that is a quick overview of where we're at. I feel good about our progress and our preparations being made for the adoption of the regulations and the launching of the application period. If you have any questions on what I've shared so far, feel free to come up.
This is Marla. One other issue that has been that we've gotten questions about relates to whether or not local governments will ask us to delay our application process. And to date, we haven't received anything formal from any local government asking us to do that. So we're still proceeding along with our own timeline as soon as we're ready, have our staff in place to continue to move forward. So, anybody have any questions? If you do, please come up to the podium there and identify yourself. Anybody on the phone have any questions? Okay, then we will go on to the next agenda item, item 5. I'm going to take the first part of this to discuss the application requirements, zoning issues, demonstrating liquidity, the ranking provisions, provisional certificates, and the denial process. You have a handout, and it just says the following points identify key provisions of ROO 4-14 and provide an explanation of selected sections. So I'll just go ahead and go through this. This is, at least from my perspective, where we have gotten most of the questions so far as we've moved forward. And again, once I conclude, we will go ahead and take questions. So related to Section 23, subsection 1 of this provision requires one person to be designated as the person responsible to provide information, sign documents, and ensure actions are taken. This provision is very important when working with us because we're going to work through that one individual, and if they're non-responsive, it will jeopardize the establishment certificate. So please ensure that the person that you appoint in that position is going to be responsive and share information as needed, and it not be a surprise if there are issues that come up that need resolution and they don't get resolved and we move forward with a disciplinary action against the establishment certificate when it's eventually approved. For those of you maybe who aren't attending in person and who are watching over the internet, this document was prepared and it's here. We will go ahead and email it out after the meeting, so I apologize that it wasn't handed out earlier, but it's just a short 2.5-page document, very brief, but I'm going to go ahead and go through it today anyway, but we'll send it out after. Related to Section 24, issues related to owners, just letting you know they'll be decided on a case-by-case basis. So we can't give any broad guidance right now. Just advise you to do the best you can, have as clear responses as possible, but we will decide those issues based on each application that comes in front of us. Section 25, this is a section explaining the application solicitation process. Subsection 2 specifies that point values will be identified when notice is given that the division will solicit applications. And although it's not specified when the solicitation is announced, it will also identify whether applications must be postmarked within a 10-day period or physically received in a specified office of the division. So we'll clear that up when we do our solicitation. Section 26, just to let you know that in terms of the references to attestation, they can be used to disqualify an applicant or revoke a certificate if it's found that information was attested to and it wasn't accurate. So again, you're signing that. You're not just signing it, you're really telling us that those are the true conditions as you are aware of them. If we find that they aren't, then that is grounds for disciplinary action or revocation or denial. In subsection 3B, we've received a lot of questions about the source of liquid assets. Applicants need to provide as much confirmable detail as possible related to how the money was originally obtained. The division will not provide advice on how to delineate this information or on whether a source is acceptable or unacceptable. Decisions in this regard will be made on a case-by-case basis as applications are reviewed. In subsection 4, there have been a lot of questions about the evidence of the amount of taxes paid to or other beneficial financial contributions made to this state or its political subdivisions. Again, applicants will need to do the best they can to identify your documentable tax contributions, and as it relates to other beneficial financial contributions, applicants should justify and demonstrate how such contributions were beneficial, and those will all just be decided based on the information provided by the applicants. Subsection 5B requires applicants to identify certain information about each owner, officer, and board member. The information will assist the division in understanding an establishment. In some cases, the information will help identify whether a proposed owner, officer, or board member has a potential conflict that could jeopardize the application. It'll be necessary to understand the regulations and what could make for a potential conflict as it relates to any of the categories. Subsection 6 requests narrative descriptions of certain areas and a resume for each owner, officer, and board member. All of this information is subject to verification and authentication. Any false information can be used to disqualify an applicant or revoke a certificate. Subsection 8 makes reference to an integrated plan for the care, quality, and safekeeping of medical marijuana from seed to sale. The law allows the division to issue certificates to 4 types of establishments, and it doesn't specify that a dispensary must be co-owned with a cultivation establishment. However, each establishment still has the obligation to identify to identify how it will meet the requirements from seed to sale. The division will not advise an applicant on how to do that and will expect that this provision be included in the application. Subsection 11 has the provisions related to the startup as well as the day-to-day operations of the establishment. We expect that owners, officers, and board members fully intend to operate in the manner specified in your response. There will be a temptation to use a template borrowed from someone else's operation. We know this, we've seen it. If you do that, read it fully, change the name so they reflect your operation, and understand each of those provisions. It won't be acceptable to say, well, I didn't know what that means. It's a template I borrowed. We find that establishments face the most trouble during inspections when they don't fully implement policies they put forward. Not understanding one's own policies and carrying them out as indicated could result in disciplinary action of the establishment. And please remember that the response in this subsection must comply with these regulations and the Nevada revised statutes. An applicant can go beyond the regulations and statutes, but you will be held accountable during an inspection for understanding and carrying out all of the aspects of what was identified in your response. Moving on to section 28, if a local government limits the number of establishments it will authorize in its jurisdiction, subsection 1 specifies 4 areas that will be reviewed to determine which applications to continue reviewing. And there's been a lot of discussion about whether local governments will allow establishments, not allow them, or require prior approval in spite of the requirement in the regulations to rank applicants. Nothing formal has been received at this time from any local government indicating a decision one way or the other. Therefore, pursuant to this version of the regulations, if a local government prohibits an establishment in its jurisdiction, such as has been done in Lyon County for its unincorporated areas, the division must still accept the application and rank it. If an applicant meets the minimum requirements of the division and ranks it accordingly, the application will be forwarded to Lyon County, and Lyon County will need to deny the application. So at the point that Lyon County denies the application, then we will follow through and deny the application. When we do our solicitation, we'll identify what the requirements are from the local governments as best as we know them. On the phone, please mute your line. Please mute your line on the phone. We're getting feedback. So again, we're going to accept your application. Remember that it's a non-refundable application fee. So if you do choose to submit an application where a jurisdiction has said that they are prohibited, recognize that that money will not be refunded to you. Subsection 3 relates to the criminal history of an applicant or person who is proposed to be an owner, officer, or board member. And this is the section I discussed earlier where we had previously specified that an applicant could resolve that within our 90-day review period. The language came back different, and we're trying to work on resolution of that right now. So this section may be revised if we move forward with a technical change. And finally, in section 29, subsection 2 of this section specifies the criteria the division will use to determine the applicant who ranks higher in the case of a tie. So all I can advise is that you make sure you're investing a lot of time or response in those areas where they will result in future ranking. And we're now open to questions. Anybody down in Las Vegas?
Good afternoon or morning, what is it? My name is Lisa Mayo. I attended the City of Las Vegas Planning Commission workshop, I guess it was last week or a couple weeks ago, and there still seems to be the open issue as to how many grow facilities are going to be awarded. We have the limit on dispensaries, but there doesn't seem to be any new information, unless I missed something, on actual how many grow facility applications will be approved. Could you address that?
Yes, thank you. So as you know, the law allows us to determine the number. We've already determined that we're going to not announce a number, but we'll do it based on the applications that we receive. So it's still a very open-ended issue. What we believe is that not every cultivator will come forward with the same product. So we feel like we have an obligation to ensure that there's adequate representation of product for patients in the state. And that will be part of our decision-making process to ensure that we've got adequate representation. We also are hoping that local governments provide some guidance back to us on what will be acceptable or not acceptable within their jurisdictions, so that we don't end up misleading someone as we put applications forward. But really at this point, we intend to base our decisions on what the universe will look like in the state based on the applications that we get for cultivation. So no true numbers, but again, the goal is for a broad inventory, I guess, for patients in the state.
I got one thing to add. All right, Chad Weston, Bureau Chief. So also, being open-ended, we are expected to ensure that there's enough production in Nevada for the patients. So as we get the applications, we'll be looking at their operations, proposed operations, and then, how much each facility can produce. And if, we have applicants that are, very small operations but well-run, and we feel like that's in the best interest of the state, then possibly there will be more establishments granted. If there's a lot of very large facilities that are well-run, then we can produce. Then there would not be the need for as many potentially. So that'll be something else we're looking at as we start to receive applications.
Again, a reminder for those of you on the phone, if you could mute your line, we would appreciate it so we can eliminate the feedback. Any other questions down in Las Vegas? Is the mic on? We can't hear anything.
Okay. My name is Brandon Parcell now. Sorry about that. My question pertains to Section 26, subsection 2, subsection D, where it states that confirmation that the applicant has registered with the Secretary of State as an appropriate type of business. Is there any specifics on what type of businesses we have to register as?
There are not.
Will there be any specifics made?
I'm sorry, that is just up to your business operation. We just want to make sure that you're registered appropriately with the Secretary of State as a business in Nevada.
Okay. All right. Thank you.
Hello?
Yes, we're still taking comment in Las Vegas. If you can mute your line.
This is Perrin.
I'm sorry, if you could mute your line, we'll come to the phone after we get our comment from Las Vegas.
Okay, thank you.
Go ahead, please, down in Las Vegas.
Good morning, Marla. Attorney Bruce Gale. I want to thank you and your staff again for doing a great job. I have a few questions. I'd first like to refer you to Section 25 of the draft regulations. I just want to make it clearer. My question is, I've read subsection A, B, and C, and I just want to, my question is, under subsection C, I want to make sure that that basically means that since I'm on the listserv, that I am going to get an email saying that 45 days is run, we're going to begin accepting applications, and I don't have to rely on subsection A, going on your website every day, or going to the legislative building or the division, or et cetera.
That is the intent. Now, we are sending emails out through our listserv. We're still hearing from people that they're not getting notification. So the best I can say is that you need to make sure that your email server allows our emails to come through. So if you haven't, for example, gotten notice of these meetings, then you need to look to your internet server, your email server, to ensure that you are able to receive our emails. We do have a confirmable list. When we send it out, it tells us, over 850 emails were received. So our intention is to do them simultaneously, but it still will not be acceptable for you to say, well, I didn't get it. I'm on the email, but I didn't get it. So that's the best we can do for you at this point. All of those other options
Thank you very much.
are legal as well.
Thank you very much. I am getting all your emails and notices, so you answered my question. Thank you very much. My next question is regarding section 26, and specifically page 7. I'm sorry, page 10, section 7, regarding documentation concerning the adequacy of the size, and including without limitation building and construction plans with supporting details. My question to you, if an applicant submits an application and owns or has consent from the landlord regarding the real property only, but there's no building or structure built yet, and it's going to be built, based on this section, I think a subsequent section, can the state consider the application and grant the application based on the plans and specifications, or does there have to be a hard structure in existence?
Yeah, we can accept on the plans.
Okay.
The key
Thank you
is
very
to
much.
ensure that the property owner or the whoever is the property owner or whoever owns the lease understands and gives authorization that they're going to allow your establishment to locate there.
Certainly. Thank you very much. I next want to refer you to section 28, specifically subsection 3, which is on page 14 of the draft regulations. And my question regards the criminal history of a potential person who's proposed to be an owner, officer, or board member. My understanding in reading this section that the word disqualified pertains to excluded felony offenses as defined under Senate Bill 374. Doesn't relate to any other potential crimes? That's my question.
You're correct. It would only go back to those specified in the statute.
Thank you. Okay. I'd like to now refer you to section 35, subsection 1, beginning on page 17, and also on page 18.
Bruce,
This
if we could
was
hold
an
off.
issue that
We haven't gotten to that section
Okay.
yet, so sorry, I know it probably isn't convenient to make you come back, but we tried to break it up so that we could keep things on track.
Oh, I apologize. I was late, so I didn't
Oh,
know
okay.
that.
So we haven't gone to the items beyond section 33 yet. We're just taking
I
comments.
apologize.
So,
Thank you
Thank
very
you.
much.
next.
Hi, good morning. Warren Markowitz on behalf of CBD Partners. I have a couple of questions relating to sections 25 and, up to 25 and 26. In section 25, there's a statement reads, a sufficient number of medical marijuana establishments. What's the basis for determination, and how is that going to be determined regarding a sufficient number of establishments after the first initial licenses have been issued?
As it relates to dispensaries, it would be if a dispensary closed or had its certificate revoked. We would then do a solicitation because there would be a vacancy in the number. As it relates to cultivators, production facilities, or labs, again, it could relate to closures or revocations. It could also relate to there just not being enough of those establishments and us needing, we're hearing that there's just not enough product available, or there's a specialty that something is brand new and everybody's wanting it, but there's no ability. So as it relates to cultivators, so some of those with those other numbers would be a little bit more open-ended than the dispensaries. The dispensaries, we would try to ensure that at least the minimum number of allowable dispensaries was always available at a local government level.
Okay, thank you. And next question is, Section 26, Paragraph 9, moves for a plan for the business to include a description of an electronic verification system. Is there going to be access to, or is there going to be a general database available from the state in regards to the number of patients, their information, and the material that's been dispensed to them in order to be able to actually accomplish this? Or is that going to be something that's going to have to be developed locally in each jurisdiction?
Can you repeat that question, please, so we can just make sure we give you a good answer?
Sure. Page 11, at the top of the page, it's section 26, paragraph 9, requires that a plan for the business, which includes without limitation a description of the electronic verification system and inventory control system. Negating the issue of the inventory control system, which is something that we're logically going to have and is required in the regulations thus far, how are we supposed to comply with an electronic verification system? Is the state going to be providing a framework of a database of the patients and the material that's been dispensed to those patients? Or is that going to be something that we're going to have to develop locally? In other words, I'm going to have to make sure that the dispensary or dispensaries that I actually own or operate have only complied with that. I mean, are we going to be complying with our
Yeah.
individual dispensement?
I
or are we going to be
understand.
complying with the state?
I understand your question. I think that we need to discuss this. I don't think the burden is on you to have an electronic verification system. The burden is on us to have an electronic verification system for you to come into. And we intend that be a web-based system. So I think we'll need to get with our attorney and consider whether or not we need to revise this section. You're correct, the inventory control system is yours, but the electronic verification system, I believe, is ours. So we'll get clarification on that piece, and if we need to do a technical change, we will consider removing that portion.
Thank you. And one last question, if I can jump back to section 25. Paragraph 8 requires a plan for testing and verifying medical marijuana. I may have missed it, but I've been looking for it. Is it required to go to an independent testing facility, or if a laboratory that is staffed properly and has qualifications equal to an independent testing facility be sufficient to comply with that requirement?
The law
In other words,
requires.
if I have a...
The law
sorry.
requires that anybody testing marijuana in Nevada must be certified as a medical marijuana establishment. So the requirement for testing would fall to a certified lab that we have issued a certificate to.
But would it be in the purview of the commission to issue that certificate to a laboratory owned by either a dispensary or a cultivation facility that has the qualifications? In other words, if I hired a scientist who complies with all of the requirements laid out here, would I be able to do the testing in-house?
No. And that's because of the nature of the independent testing lab. There cannot be any affiliation between a lab, a dispensary, a cultivation facility, or a production facility. We have to maintain that clean separation and independence based on the law.
And how are we supposed to comply if a laboratory hasn't been licensed upon the expiration period of the application process?
We do anticipate getting applications from labs. If we don't get applications from labs, then we're all going to be in a world of hurt, I think. But at this point, we anticipate receiving applications and that there will be labs available to do this testing.
Jim Dorsey.
Thank you very much.
Hey, Haley, can I call you back? I'm on a conference call right now. You still there?
Whoever just asked for Haley, if you could mute your line, please. Anybody else down in Las Vegas? Questions related to the application process?
Good morning, Marla. I apologize, Attorney Bruce Scale again. I didn't ask you about subsection 28, specifically subsection 1, involving the ranking of the applications. So, to make my hypothetical question more simplistic, let's assume my question pertains to there's no local jurisdictions that have put a limit on the amounts of medical marijuana establishments. So we're talking about a statewide, an application being based on all the other statewide applications. My question to you is, I know there's statutory preference for seed to sale under Senate Bill 374, that one factor. But my question pertains to if an applicant hypothetically applies for, let's say, cultivation facility and a dispensary and a production facility. And are you going to look at the scoring for each sub-application and compare it to all the other applications for those same similar establishments on a statewide basis?
Each application will be evaluated separately and ranked separately. So there is an outside chance that a portion of the application could be approved and another portion not be approved because of the ranking.
Okay, let me ask a follow-up question. So if an application applies for more than one certificate, let's say 2 or 3, that application will not be compared to similar applications where they're applying for the same type and amounts of establishments. You're going to look at each one separately or not?
So the numbers are limited for dispensaries in most jurisdictions. We'll rank all applications that we get, for example, unincorporated Clark County, whatever the number is, we'll rank all of those. For cultivators, we're going to have a different set of criteria that we look at. For production facilities, a different set of criteria that we look at. If there's a limit on the cultivator or production facility, then we'll have to rank based on the limits.
Okay, thank you. That leads me up to a third follow-up question. So let's say, from a practical standpoint, there are 4 major local governmental jurisdictions in Clark County under Senate Bill 374 that could qualify for 25% or up to 10 of the 40 dispensaries. So are you going to look at all the applications for Clark County separately, all the ones for the Incorporated City of Las Vegas separately, all the ones for, let's say, Incorporated City of North Las Vegas separately, and the Incorporated City of Henderson separately, assuming they allow them in their jurisdiction? Or are you going to just pull them all together and consider them all Clark County?
No, we'll look at them all separately. So it's really, again, essential that the local governments declare whether they're in or out as it relates to any of the establishments, so that the county can then move forward and redistribute the percentage. If there's no redistribution of the percentage, then we will fall back to what we believe their percentage is and rank within each of those jurisdictions.
Thank you very much. I'll wait for the next sections. Thank you so much again.
Thank you. Anybody else down in Las Vegas?
Good morning. Charlene Lewis McGinnis from Green Life Dispensaries. I'm kind of wondering about the timeline. There's been notification in the writings about request for qualifications. Is this the same as a letter of intent, to where you will ask us to send the letter of intent and the first $1,000 non-refundable?
Thank you, Charlene. So the letter of intent option has been replaced within the current version of the regulations. So what we have at this point is a solicitation that we will do 45 days before we open our 10-day application window. And then we've further delineated criteria that allow us to do the ranking for applicants where there are limits. But the current version, R004-14P, is what will guide us the rest of the way out. So there is no longer a letter of intent provision.
Okay. And then on the jurisdiction, if we're looking at a location in, say, the city of Las Vegas, and they have not decided to allow that, then if we go through the approval process with you, and then they decide, it will then go through you and then to them for approval?
I'm sorry, I'm not sure I understood the question, but when we solicit applications and open our 10-day window, we're obligated to take all of the applications that we receive and proceed with ranking based on how the regulations are written right now. If a jurisdiction makes a decision after that they're not going to accept, for example, dispensaries, then we have to honor that decision, and they would then deny the applications, and then we would follow up with a subsequent denial. We've allowed, if there is space for an applicant to potentially try and relocate. I don't know how realistic that's going to be given the timeframes we're working in, but at least it is allowed if that does happen after we move through our process.
And then just for clarification purposes, liquidity would need to be determined for each segment. $250,000 for dispensary, $250,000 for cultivation, $250,000 for production, and $250,000 for a lab.
That's correct.
So if one company was going to do 3 of the 4, they would have to show liquidity of $750,000.
That's correct.
Thank you.
Anybody else in Las Vegas? You want to go up, just fill the chairs in, and we can kind of keep moving forward. Go ahead.
Hi, my name is Barry Steep. I'm with Third Day Creation. My question pertains to ownership, trying to keep ownership within the state of Nevada. I've read articles about large corporations from California coming in to set up operations here, and I'm wondering if there's going to be any kind of weight given to longer-term residents or permanent residents here of the state of Nevada. Thank you.
The criteria that are specified in the regulations are the criteria. They don't right now specify being in-state or out-of-state as having any higher preference. So it's essential to understand each aspect of the regulation to respond appropriately, but that is not a criteria.
Hi, Chad Weston for the record. And following up on that question, and also I believe it was Attorney Hale's question, as we're looking at those applications and reviewing them and ranking them, we'll also be looking at NRS 453A.326, which down in subsection 2B, or 2 and B, to prevent monopolistic practices, the division shall ensure in a county whose population is 100,000 persons or more that it does not issue to any one person, group of persons, or entity the greater of more than 10% of the medical marijuana establishment registration certificates otherwise allowable in the county. So we'll have to be looking at not just dispensaries, but all establishment applications, and then as we receive them and we're ranking them and we're having conversations with the local authorities, that we comply with that law as well.
Go ahead.
Thank you. My name is Michael Levinson, and that's to follow up on the last statement just a moment ago, which is there is a set number, or a relatively set number currently, of dispensary certificates that will be allowed. The number of processing and cultivating facilities has not, as I understand it, not yet been determined. But to what degree will the ownership of the other two, meaning processing and cultivating, be factored into your overall percentage ownership, if you understand what I'm saying? So if there's, say, 40 dispensaries, and just picking a number, 10 in Clark County, 10 cultivation facilities and 10 processing facilities, just as numbers, is it 10% of the 60, or is it the total number of 60, or is it 10% of each of the category of facilities that you can own? Hopefully I've asked that in a way that makes sense.
I think I understand. We believe it would be 10% of the entire universe, not just 10% of dispensaries or 10% of cultivators, but 10% of the entire universe.
Okay. Thank you very much.
Anybody else in Las Vegas? All right, let's go to the phone. Anybody on the phone have any questions? And please remember, mute your lines. If you're not talking, open your lines if you have a question, and then remute them.
Mute your lines. If you're not talking, open your lines if you have a question, and then remute them.
And if you're listening on the internet, you might want to mute that as
Your
well.
lines. If you're not talking, open your lines if you have a question, and then remute them.
Okay.
Go ahead on the phone.
All right. Hi, this is Dan from Pahrump, County Chairman.
Go ahead, please.
Thank you. My question is, we've been working on getting our zoning and our licensing. We'll be hearing licensing next month. But we've been hearing that the date to apply, April 1st, has been put off. Is that true? If it is, how far are we looking?
So Dan, thank you for your question. Chad Weston, Bureau Chief. So we have the regulations that are drafted. We're discussing here today. We plan to go to Board of Health in March, and we hope for a smooth process to where they're adopted. And then that will fulfill our requirement by the law to have regulations in place by April 1st. The application period, where we announce the 45-day time frame that we'll be receiving applications for medical marijuana establishments, that time frame has not been set. There's lots of, even topics we're discussing here today that factor into that. There's not a hard date that where we're going to receive those applications. It was not April 1st previously, and it hasn't been delayed either. We're still working on those things. Does that help, Dan?
Okay, so if I could then, if we have our zoning in place and everything by the middle of April, the people who are interested in opening those establishments up here still wouldn't miss out on the date. It's still going to be some time before you announce the accepting of the applications.
If you have your local requirements completed in mid-April, that would be helpful for the establishment applicants. And,
Okay.
we would appreciate that. And, you would be in good shape for reviewing the applicants at the local level, possibly parallel to the state's review under our criteria here under the regs.
Okay, great. Thank you. And just to be clear, April 1st was never the cutoff, but we will give a 45-day warning when you're going to take the applications.
That's correct.
Thank you very much.
Thank you.
Anybody else on the phone?
Yes, this is James Hello? Hi, this is James Barlow. I have a question regarding the definitions for Section 13 and Section 5. They both refer to processing something that's other than inhalable or ingestible. So does that mean that a cultivator could process down their product into not only the dry leaf form, the bud form, however, smokable resin type of product?
I don't believe that it does. I believe a cultivator cultivates, and anybody else who wants to alter the product would have to do it through a production facility.
Okay, so even though, for example, an infused product which would allow you to produce an oil, but that oil, pursuant to Section 1B, is anything other than through inhalation. If that oil was only to be smoked, per se, would that be something that the cultivator could do, though?
I don't believe that the law envisions that. I think the law says there are 4 types. One of those is a cultivator who grows. One is a production facility who does any alterations. And so if someone wanted to if that's your business plan to do both, you would need to submit an application for both and identify how you intend to carry those activities out. But you would require separate certificates for each operation.
Okay, thank you.
There was someone else on the phone?
Yes, good morning. Jeff Harrison. Thank you. Please stop me if I'm referencing a section that you haven't gotten to yet or you plan on taking care of a little bit later in this meeting. We've noticed in the regulations that delivery is mentioned on many occasions, but I have not seen yet something that's dedicated to the process of delivery, the hours of operation, and the machinations of what that would look like. Could you address that, if at all, at this moment?
Yeah. Hi, Mr. Harrison. It's Chad Weston, Bureau Chief. We'll be going over a good portion of the regs today here shortly, and transportation's mentioned in the latter part of the regs that we'll discuss. And, once we get through that, if you have further questions, specific questions, we'll do our best to answer them for you.
Great. Well, let me move to my next question. I've actually got 3, if that's okay. The next question is has there been any regulations that have been promulgated or that you're talking about at present that are going to address the initial inventory or stocking of a potential dispensary that would be opening, and whether that product would be coming from within the state of Nevada or from other states?
Yeah, it would not be legal for the product to come from anywhere other than a Nevada certified facility.
Understandable. Does that also include the infused products or the edibles?
That's correct. They also require to come from a Nevada certified facility.
Okay. One moment, please. Last question, if you can address, and I don't know if this has been if this has been looked at. Obviously, I think we're all aware that there are existing delivery services that exist presently in Nevada and the greater Las Vegas area. How, if at all, is that going to be considered when the application process is opened? Is that going to be looked at as something that is a negative or something that's a positive, or is there any view on that at all at this moment?
I think the view is that they currently operate outside the limits of the law, and that an applicant, the delivery is really limited to a delivery to a patient in a very limited amount, or delivery from a cultivator or production facility to a dispensary, or from those entities to a lab and then back. Those are provisions that need to be identified in your application, but a delivery service is not something that will be licensed separately, because there is no provision in state law to license a delivery service.
Right, and I guess what I'm asking is if the folks that are operating it presently, sort of on the outline of the law here, are they going to be frowned upon in the application process for a dispensary or any of the four categories?
The only criteria that we have to measure relates to the criminal background checks. As the applications come forward, if it's an application for a dispensary, it has to clearly identify a model that works within the existing legal framework.
Okay, thank you very much.
Anybody else on the phone?
Good morning. Robert Summers in Reno.
Go ahead, please.
Hello?
Yes, go ahead, Robert.
Oh, thank you. Sorry if I missed just a quick question. The positions, do you have those filled, the inspectors, the auditors, the administrative support staff, that kind of thing? Do you have those positions filled already, or when do you anticipate them if you don't have them filled?
I've got it. Okay. Mr. Summers, thank you for the question. Chad Westham, you mentioned the positions. As I said, there's 12 state positions that have been allocated and authorized for this program. We're starting the process to fill those positions. They have not been filled. We have a staggered approach. I can share with you that we'll be bringing on staff that will be assisting in the application review process, and then other staff will be brought on as we get closer to the facilities being built and the inspections required, and then the initial opening of the facilities or the establishments and their inspections. So it's a staggered approach. The positions we're starting through the actually we're quite a ways through the hiring process. It's takes a little bit of time and effort at the state level, but we're well on our way.
Thank you.
Any other questions on the phone?
Yes, one question about concentrates production and oil production, which is also a part of the kitchen manufacturing process. Have you guys addressed, or is that a separate license that you have to apply for within an application for concentrate and oil manufacturing?
Yes, hi. Chad Westham again. We'll be just going over, actually, at the next stakeholder session, we'll be going over those regulations more in detail. But to answer your question, if you're going to be producing edible medicine or other infused products, that would require a separate establishment certification and of course, an application when we specify that time frame, and the dispensaries and the cultivators and laboratories are also applying. Oh, and actually, to follow up on that last question, the previous question about the positions, maybe it'll save you a call or confusion for anyone who's interested. The state positions that'll become available, they'll be posted on the state Department of Human Resource Management, or DHRM, and you can find those there if you check back, and you can apply through the state system if that's something you're interested in. You don't need to. You want to monitor those websites rather than calling us and asking. They'll go up on the website as soon as they're available. There are none there yet. All right, did I answer your question about the infusibles and edible medicine?
I think so. I'll touch back on that once I read through the entire regulatory system you guys set up. So thank you.
Okay, it's towards the back.
Anybody else on the phone?
This is Steve Fox with Vicente Cedarburg. Just a quick question related to your interpretation, I guess would be, in the statutes 453A 326, you referenced it earlier, the monopolistic practices, where it said that no person shall have the greater of, more than 10% of establishment certificates. How would that be measured? That one person, would that be a majority owner, or any ownership interest in an establishment would count toward that? Could you have a 5% interest in more than 10%, or I guess that could be enough to lay out the question. 5% interest, more than 10%, or?
Thank you for that question. Unless Marla's got some insight on that one, we're going to have to evaluate that as the applications come in, and we'll be discussing items like that come to our attention with the Attorney General's office to make sure that have the appropriate interpretation of the statutes. And so I don't have a clear answer for you on that one at this time.
Mr. Westham is correct. I mean, it will be decided on a case-by-case basis. So just ensure that if you are applying for multiple facilities, we're basically going to add it up cumulatively based on what you identify as the ownership percentage.
Mm-hmm. Might that be defined before the application process, like what you're saying just then in terms of adding up ownership percentage? I mean, that seems like a definite standard. But then you say it might be case by case. So,
well, there's 5% or more ownership that requires disclosure. So, in the regulations. So we're trusting that people are identifying the percentage of ownership, and that there's an expectation that be done, and then that becomes cumulative over multiple applications.
Okay.
Any other questions on the phone? Okay, let's move here to Carson City. Anybody have any questions in Carson City? If you want to come up, just fill in the chairs and we'll just go one by one. Go ahead and fill in the chairs and we'll just keep moving through.
Hi, Chris Hempel. I have a question about Section 26, number 4, which details the taxes. I'm curious to know if every person on the application needs to provide their tax information and essentially how to do that, if that needs to be a letter from an accountant or the front page of a tax return, and just if everybody needs to do it or if a subset of the people that are part of the application need to do it.
Again, that's a section that allows you to be ranked against one another, so I advise doing whatever you think is best. We're not going to give specific advice on what's acceptable, what's not acceptable, or how to do it, just that it's your burden to demonstrate how you meet it, and just keep in mind that it's a ranked provision.
Thank you.
Shane Johnson. Question regarding section 2610B, where you state that if the applicant is relying on funds from an owner, operator, or partner, evidence that such person has unconditionally committed such funds to use of the applicant. I'd just like to clarify that somewhere in the owner, operator, or presumably partner, that you would be including third-party investors in that who may not be operating partners or owners.
So the section says if the applicant is relying on money from an owner, officer, or board member, evidence that the person has unconditionally committed such money to the use of the applicant.
I'm saying.
I'm sorry, am I in the wrong section?
2610B, quote, if the applicant is relying on funds from an owner, operator, or partner.
In the proposed version,
Yes,
the partner language was actually, the partner language was in the version that we submitted to the Legislative Council Bureau. When it came back from the Legislative Council Bureau, it was revised to board member, which is consistent with what the statutes say.
So what you just left printed out there was
Yes.
not the revised version?
LCB R004-14. So did we not print the right one?
I'm just reading your blue cop. I'm
The
reading a
copy you have, the cover page of it should say proposed regulation of the Division of Public and Behavioral Health.
Correct.
LCB file number R004-14.
Correct.
My subsection 10 says, 10B, if the applicant is relying on money from an owner, officer, or board member.
Well, would you like me to walk my version up?
But board member is the appropriate term.
Well,
Partner.
I guess the question is, I'm assuming that people applying for an MME, that it is a viable source of funds to have a third-party equity investor or debt investor who may want to invest in this business. I'm assuming that somewhere under this we can simply provide evidence that they are willing to commit such funds unconditionally. Is that correct?
That's correct.
Okay. Second question, and this is really a follow-up on the prior questions regarding the anti-monopolistic behavior and a 10% cap of ownership of MMEs in a given jurisdiction. I guess prior to today, it seemed fairly clear to me that that was in reference to dispensaries where there's a set cap. Now it seems somewhat confused to me in that it seemed, take Douglas County, for example, where there can only be one dispensary there. The moment then somebody would apply to, assuming a dispensary gets licensed or is considered, the moment somebody applies for a cultivation facility, that cultivation facility would automatically be a 50% of the MMEs there and therefore not eligible, or certainly, I mean, if two people applied for a cultivation facility, I guess it just seems...
Did you mention Douglas County?
Yes.
Okay, so there's not 100,000 people in that county, so that section of the law does not apply.
Okay. So take Washoe County then, and I appreciate that clarification, but in Washoe, would there then be a bias against a seed-to-sale operation being done in Washoe County because you would have more, both a cultivation and a production and a dispensary all in Washoe, or should the cultivation and production be located in another county to get around this stipulation?
We have the law, we have the regs, it's maybe a three-legged stool. We'll have the applications from the people who want to open up medical marijuana establishments. We'll see what's proposed, and then, if you can mute the phones, that'd be helpful if you don't mind, if you're not speaking. And then we'll factor all that in, and we're working on some analysis to where we can project maybe what decisions might be made. But a lot of it will be based on what we receive. We also have a lot of we have conversations going on with local authorities as well and their perspectives, and we'll be partnering with them as much as possible. So that question is too complicated to answer at this point.
Okay, thank you.
But it is driven by NRS 453A.326.
Attorney John Gaslin. Under Section 26A3, it says that the applicant has at least $250,000 in liquid assets, which are unencumbered and can be converted within 30 days after a request to liquidate such assets. What are the parameters of the request to liquidate by the division? And what would trigger that request, I guess, is my question.
You know, I mentioned before, as I was giving you an update on where we're at programmatically, those are among the topics that we're developing some responses to, and we don't have that yet. You know, the important thing for the application will be that you can show the $250,000 of liquid assets.
Now, as a follow-up to that, let's say an applicant had the $250,000. Are they going to have to keep it in an account for possibly this request to come through, or are they able to use that in setting up their dispensary or the cultivation or the edible facility?
The purpose of the $250,000 amount is to be able to show it for the application process, and so that we, the division, can review it and verify it. You know, how it's used once you start the operation and you start building, that would be, you know, that'd be up to you. We're not. We just want to make sure that the businesses are appropriately funded to start up. We're not seeking. It's to get through the application process. That's our primary objective there.
And that's how I read the regulations. However, that the request to liquidate it seems nebulous, or it seems like it's unclear why that would be.
Yeah, I agree. I don't think there's any specific. We won't be requesting that you liquidate it. The important provision is that it can be converted within 30 days after a request to liquidate. So it's demonstrating that it can be converted. That's the key.
So that facility has the
days.
ability to use those funds if need be.
Right, within 30 days.
Okay, thank you.
Hi, Adam Mintz, Steep Hill Lab. I had a question regarding the discussion earlier over cultivation permits and how you guys would be looking at those permits. You'd mentioned, I guess, something that kind of sounded like variety for the marketplace. Do you know what you will even be looking for in terms of variety, what that definition means? Are we looking for high CBD, high THC? Are we looking for varieties of different types of strains? Do you envision anything that you might have an idea to maybe guide people who are doing cultivation licenses? You know, what does this variety that you're discussing refer to?
Thank you for the question. We don't have an idea, and we don't have any preconceived notion. We just are aware that some entities are specializing, and that our obligation, again, is to ensure that if an application comes forward and it's the only one that proposes to do a certain thing, we make a decision on whether or not that's beneficial for our patient population. So we aren't soliciting anything. We are really taking it on a case by case, depending on the applicants and what they identify in their applications.
Thank you.
Yeah, again, Walter Marting, I'm a private citizen. A couple of just quick questions. Earlier you'd mentioned that 60 was the cap as the number of medical marijuana dispensaries, and that if there was a revocation or somebody dropped out of that number, you would then take action to make sure the number was filled. I'm just curious if there's been any discussion, determination as to how long that cap over time would be in place. I mean, in 2 years, 3 years? Is this something you can look at each year?
Thank you for your question. So the cap is actually a product of the legislation. And the 2015 session of the legislature is coming up a year from now. And I presume that if there's a need for them to revise the overall cap, then they'll do that. In that case, then we would have a different set of criteria. If the number doesn't change, we don't have the authority to change it.
Okay.
We would just act on filling any vacancies.
All right, great. And then just quickly on the application itself, it wasn't clear. That's maybe because I read an older version of the application form. Is a doctor, MD, required to be an advisor to a dispensary as part of their application team?
No. No, that provision was eliminated.
Okay, good. And I guess you're going to talk more about the inventory, initial inventory sourcing, which came up in the course of discussion, but it's talked about later in the regs.
The law allows for some purchasing from existing growers. It's very limited. Other than that, the expectation is that any product in a Nevada dispensary comes from a Nevada cultivator.
Okay, so that cultivator would have to be certified, but the
Correct.
private grower who's growing now wouldn't necessarily or wouldn't be certified.
Correct.
So that initial stocking could have a component that's not.
These regulations identify if someone does choose to buy from an existing grower, that they be identified, but keep in mind that there are limits on what existing growers can even have. So someone who buys more than the limit would need to document that, and we would make a decision based on that documentation.
Okay, but you'd need that documented as part of the application, where the sourcing was coming from or would come from?
Yes.
All right, thank you.
Hi, John. So are you guys under the assumption that all of the strains of cannabis that are going to be developed in the cultivation process are going to be Nevada original specific strains?
What we're saying is that any dispensary must buy its product from a Nevada certified facility.
Okay, but for the startup process for the cultivations, where they originally get their original strain, is there any discussion of that yet?
No.
So then you right now, we're under the assumption that every strain that is going to be developed in the cultivation facilities is going to have to originate from a Nevada grower under the current scheme. Is that right?
I think getting involved in the strain discussion is probably beyond my ability to handle at this point. People have to be able to demonstrate their inventory, where they obtained their inventory, and it needs to come from a Nevada source. That's the best I can say at this point.
Okay, thank you.
Okay, we're still taking comment here in Carson City. Go ahead.
Thank you. My name is John Sutton. Regarding the point the gentleman who was previously here brought up, it's related to Section 25. So we talked previously, Marla, I think it was either you or Chad who brought up the cap. And the question I have is, you've articulated a bit of a closed-in system, and there could be a scenario in which a certificate is revoked or a party goes out of business, et cetera. And then you talked about creating a mechanism to replace that entity, that MME in effect. So the question I have is twofold. One, is the replacement timing going to correlate to the 10-day window, or would there be some immediacy in terms of replacing that MME that, for whatever reason, ceased doing business in Nevada?
So there are, I think, two things at work here. One being, we are soliciting applications this year, and we're ranking them, and we're sending them to the local governments. And let's say that someone got a provisional certificate from us, got moved to the local government, couldn't comply with the local government provisions, and was denied, and then we deny them. We're going to go down to the next ranked applicant, process that, and move it through for this time period. Once we've closed and we've gotten a sufficient number of establishments for this year, then we won't fill any more slots. If there's a vacancy then at the next year, in 2015, then we have to open up a new 10-day window to solicit new applicants. We won't fall back to our existing applicants from this year. We would open up a new application period and be clear about what we are accepting applications for. It's one dispensary salad in Reno or whatever it is, we would be clear about that.
You answered both of my questions with one answer, so it's elegant. But another question, the reason I was asking it was in terms of if it was in the immediate term that you were looking to replace dissolved MME. In effect, you could fall back on a stacked rank preference for those applications that, while they showed merit, didn't receive a registry certificate, in effect. And then they would be able to leverage their previously submitted fees within the fiscal year. But what I'm hearing now, just to make sure I understand, is that no, you wouldn't replace it in the immediate term, an MME that had been dissolved, but rather that unit, if you will, would be open for another application during the following year's 10-day application period.
I think it is not something that's got a black and white answer today. It really depends on the circumstance and where it falls within the process. Dispensaries, it's a little bit easier for us to make that decision. If they're denied and we know that there's an open slot, we're going to fall, because we believe that would have fallen within our current application period and it would be acceptable. Others, we're just going to have to decide on a case-by-case basis, and always keeping in mind fairness to everybody who wants an opportunity to compete. So what we've said in our regulations, that if someone surrenders their certificate, that they couldn't reapply until a new application period comes up. So those are things that we would consider based on the regulations that would become part of our thought process.
One other question, and if it is not appropriate to answer it in the context of the first 33 bullet points, let's not do it at this point. But I just took a note, and Chad, it was based on a comment that you made in terms of, another gentleman brought up the preference within the NRS for seed-to-sale operations. And we envision standing up a robust seed-to-sale operation. Our preference in terms of distribution of our own product, of course, is going to be to our own MMEs, our retail footprint, if you will. There could be some MMEs, dispensaries, that simply might have difficulty based on the numbers of cultivation units you initially stand up, finding product, since you simply cannot source it outside of Nevada. Another point that was brought up recently. The question is, would the state ever envision getting into the business of mandating that a cultivation unit that potentially had overage in terms of inventory, mandating that they distribute product to dispensaries that don't have a back-end cultivation unit that are running low on inventory?
I don't envision us mandating that. We wouldn't have the authority to do it. The authority we did write into the regulations is to control overall production. A dispensary only applicant needs to identify how they intend to maintain their product. They have to be operational within 18 months. So there's no limit on any cultivator selling from any dispensary that wants to buy on a wholesale basis. There's no limit in the regulations or the statutes. So that's where we're at.
Thank you.
Anybody else here in Carson City? Okay, let's go ahead and move on then, if we can, to the next agenda item.
Okay. All right, that'll be agenda item 5B. So again, Chad Westham, and I'll be looking at section 33 and forward. And I'll be giving you a quick overview of to the sections on inspection and oversight of the establishments, some of the operational requirements, surrendering a certificate, the renewal process, agent cards, cardholder verification, and delivery services. So I guess as we get to a section where you have a question, feel free to come to the table, and I'll take a break periodically and try to answer your questions that we've gone over, because I'd like to hear your questions rather than just hear myself speak. All right, so just as a reminder, I referenced the statutes in a previous question that we had, and so starting in section 33, we've set up these regulations, and these establishments, whether they be dispensaries or cultivation facilities or production of edible medicine or infused products, it's a privileged certificate per the statutes, and so we will do our best to work with you and keep the operations as tight as possible so there's not any sort of inappropriate distribution outside of lawful means. All right, so it's in section 33, the division at any time may perform an inspection or an investigation of the premises, as well as the qualifications of personnel, methods of operations, policies, and any person proposing to engage in the operation of a MME. Basically, what this section, the summary of it is that the division will investigate and we will do inspections at your facility, not yours, but at the medical marijuana establishments as much as necessary, and when we see fit to ensure that the spirit of the statutes and these regulations are carried out. So going to subsection 2. Indicates that the medical marijuana establishments will complete an inspection of the facility before the certificate is issued, and that will be required before the certificates are issued. Some might have had the impression that we would do the application and review and rank them, and then certificates would be issued, and then you would stand up your business. And to a degree, that some of that will be true, but we'll have to do an inspection before you begin operation. That's pretty standard with other facilities and establishments before issuing the final certificate, if that helps you. And that's standard in the division with other facilities that we license or certify. Okay, so anyway, and then going into subsection 4 of section 33, this indicates that the medical marijuana registration certificate will not be issued until there's full compliance with applicable public safety inspections required by state and local jurisdictions, including fire, building, health, air quality inspections. And it says, except as otherwise provided in subsection 3 of section 63, which is later in the reg. That's standard. We'll be expecting inspections from the local governments as well. The caveat there, the section 63 pertains to the edible medicine production. That will be something that we will have trained inspectors able to inspect and regulate. The intent of the statutes and these regulations is that the edible medicine is not food, it's medicine. And so we'll be performing those inspections as part of our regulatory process. There will not be a requirement or expectation that a local health district would need to do a food inspection. That won't be necessary. Okay, so moving on to section 34. This is just the section where it talks about that the medical marijuana establishment needs to be fully operational within 18 months after they've received a certificate. But otherwise, if that doesn't happen, the division does have the option to possibly revoke the establishment registration certificate. And, annual renewal fees paid by the establishment are not refundable. Subsection, I'm just going to skip on down to subsection 35. Okay, so if this, if a medical marijuana establishment all right, this is about if the establishment doesn't choose or want to move, this section is talking about, the processes that are necessary. If the business is moving with greater than 5 miles or there's significant local approval needed, the establishment would need to surrender its certificate and reapply during the next request for applications issued by the division. And you can see that as it goes into the next sections. And then skipping on down to section 35, subsection 4, and this is on page 18 of the LCB draft. If the establishment does need to close, the manager of the establishment must notify the division of its closing at least 15 days before the medical marijuana establishment is closed, and it must surrender its registration certificate to the division immediately upon closing. Subsection 35, I'm sorry. Yes, section 35, subsection 5, page 19. If the division finds upon investigation that the establishment has changed its ownership or made other changes that circumvent NRS 453A.334, which prevents the transfer of medical marijuana establishment certificates, the division will take action to revoke the establishment registration certificate. And then subsection 6 of section 35, also page 19, the medical marijuana establishment is responsible to the division for all costs incurred by the division to determine whether any changes in ownership or other changes have been made according to the statutes preventing the transfer of an establishment registration certificate. So just highlighting those for you. Any questions so far on these sections before I go to section 36? Sir. We have questions in Carson, then I'll go to Las Vegas and then to the phone.
Just real quick, on the 35, the transfer of the 10% interest, triggering a surrendering of the certificate. If there are two owners of an existing MME, one has hypothetically 80%, the other has 20%, and the 80% owner wants to sell 10% to the 20% owner, does that trigger this surrender? They're within the already approved structure of the dispensary or MME, as the case may be.
Well, I believe it applies to outside of the existing ownership.
I mean, I would think so, it doesn't say that.
Right.
That may be.
So you could transfer it within your internal ownership and adjust it, but if you are transferring it, moving it to someone outside of the existing ownership, then it would need to be surrendered.
Okay. And I think just for the record, the copy of the regs that you have outside there is the copy you submitted to LCB. Their revisions are not there.
Thank you.
Apologize for that.
In regards to section 33.1, with the division at any time at its discretion being able to inspect the facilities, is there going to be a process in place to verify in some sort of real time or in advance the identity of the inspector or auditor? Because I wouldn't want somebody to show up and present some sort of false identification and have that then be the entry point for some sort of criminal activity against the MME.
It's a good question. All of the employees that would be coming into your facility, not all, but like the inspectors, they'll have a badge from the division. We can think about if additional verification is necessary, but you are always, always would have the option to call their office, call headquarters, call myself to verify their identity. And we will make ourselves available, and we'll try to be as helpful as possible. with that.
Okay, thank you. Yeah, I guess a badge is fairly easy to, this day and age, to make a
Right.
a very good replica of. So just even photo, perhaps some sort of photo distribution in advance of here are the valid inspectors that's only from this subset of 6 people who may be showing up at your facility, or just some other mechanism might be
True,
appreciated.
and it's a smaller staff, so that is very feasible.
Understood. Thank you.
Okay, questions in Las Vegas on the sections 33 through 35 so far?
Yes, hello, John Sandy, for the record. I had just a few quick questions and some clarifications. At the last December 23rd hearing, we did discuss the meaning of fully operational. I see that it is permissive for the division to take action, so maybe doesn't need much clarification, but for example, a cultivation facility, are they going to be considered fully operational at the time they're actually growing, or at the time they're making wholesale transactions to retail establishments, et cetera? How is the department going to determine fully operational? Do they want the operators to send notice to the division when they're operational, et cetera?
Thank you for that question. In terms of a cultivator, and we've become familiar with the requirements for growing here lately. So if the facility is operating and all of the requirements of the regulations are being implemented and they're growing, I would consider that operational. Making sales after the product's fully grown and processed would not be necessary, and that's my perspective at this moment.
Great, thank you. Then also just a quick question on Section 35, and this probably is a little bit more important because of the revocation provisions, but I guess first for kind of a technical change, and I did reference this in my comments on the 23rd, and so it's probably my mistake, it's there, but you do have 10% or more of the stock of the medical marijuana establishment, so it doesn't contemplate if you're in a limited liability company with membership interests or partnership interests. So maybe technical would want to allow that so you can transfer those interests as well, at least under the definition here. The other question I have is under subsection B. And I do think it's actually kind of clear in the language and based on your comments, Chad, about moving locations, and I think that's what you're talking about. But then on subsection B1, it says a materials change that requires a MME to go through an approval process. I'm considering in my head if some of these cultivation establishments or even dispensaries for that matter might want to determine what the demand is before they grow and expand their operations. If you have a cultivation facility, let's say for example a 10,000 square foot facility but has the ability to grow into a 30,000 foot establishment, but you need a local government permit or approval for that, would that trigger this this section? Or are you only referring to the physical location, and would it maybe make sense under section B to change in the physical location of the MME?
That is a good question. This section is talking about changing location. Each case will be considered case by case. The focus of this regulation is if they change location. If you have like you said, a 10,000 square foot operation, but you're able to expand to continue doing the same thing that you're authorized for, I wouldn't see that as triggering. But again, be case by case. If you expand and then you're making a huge significant change, then the locals have to be involved and they have their perspective, then that could be problematic. But
yeah,
hopefully that
I
answered.
totally understand that we all kind of understand that we might all agree on the language here, but this section does say that an MME must surrender its registration, so the penalty is pretty thick if there's a misinterpretation on that. So maybe I'm just suggesting it might make sense to put that physical location so everybody's clear, so we kind of avoid hopefully that scenario.
Well,
but that's all the comments I have.
So this is Marla. I mean, I agree. I guess we can specify it's the address, but I think the location is the approved location. And if there is a material change, and then subsection 2 allows for certain situations that if you got prior approval, you could potentially move your location, your physical address. So there are pretty limiting conditions under which anyone could move. If you're looking to expand, that's a different entity. Your operation was approved at a certain, based on your application. And if it was approved at 10,000 and later on you wanted to go to 30,000, that would require you to reapply in a new application period.
Okay, thank you for that clarification.
Good morning, Attorney Bruce Gale again. I have a comment or some comments regarding Section 35. As y'all, I'm sure y'all recall back, I believe on Monday, December 20, 2013, when there was the first public comment period on the set of draft regulations in, the Section 35 probably got more comments than any other section. I hope I don't sound like a broken record, but I want to talk about subsection 1. I know there was discussion, suggestions by myself and I think other people back in December that this language regarding surrender of a registration certificate was very onerous, and that the preferred procedure would be that a medical marijuana establishment or its owners are prohibited from transferring any assets or ownership unless they submit, or the proposed transferee submits applications to the state for possible approval, just like a gaming application. My second comment refers to subsection A. And assuming you're going to keep subsection 1 the same, the last word in there is and I don't know if, I mean, the way subsections 1 or A and B are drafted now, it's less onerous on the medical marijuana establishment, but I don't know if y'all want this in the disjunctive, and that should say or. But I think you know where I'm coming from.
Thank you, Bruce. We'll take that under advisement.
Thank you.
Okay, thank you. So Carson, Las Vegas, any comments from the phone or questions actually on the sections 33 through 35? Okay, all right, so we're moving on to section 36. This section is talking about, establishments that, or a person or entity that wishes to renew a medical marijuana establishment certificate. What you're going to find is that to renew your establishment certification, you'll be providing a lot of the similar documents that you had to provide upon your initial application. And so there's application, identification number, the names. Moving on to page 20. The proposed hours. What is going to be an addition with your renewal application is that with your renewal, you'll need to submit the financial statements for your operation during the months of your operation, and also an audit report prepared by a certified public accountant or CPA. And if you'll You'll see that on, listed on page 21, subsection 3 there. Okay, so it's section 37. And again, after a number of sections, we'll take a break and, give you a chance to ask questions. All right, so section 37 does indicate for you that submission of an application for a medical marijuana establishment does constitute permission for entry to and reasonable inspection of an establishment by the division, and it does spell out that an inspector conducting the inspection does not need to be accompanied during the inspection. But I wanted to mention to you that that's not going to be required that they be accompanied, but, we do seek to have partnerships with the businesses that we're regulating and inspecting, so they might ask, you might find that they ask for you to accompany them during all or part of the inspection, and, that would be appreciated so that they can get their questions answered. But then if there's a complaint investigation and things need to be looked at in more of a confidential manner, then that would be where they would not prefer an accompaniment. So subsection 2 of section 37, bottom of 21, talks about complaint investigations, and that the medical marijuana establishment, that there'll be complaint investigations on topics that are addressed in the regulations, with the exception of customer service issues. That's not going to be something that we will be looking into. Possibly, there'll be other entities that might want to look into that. We'll do these investigations with or without notice if necessary into the premises, facilities, qualifications of personnel, method of operations, policies and procedures and records, etc. The division will need to enter and inspect building and premises at any time with or without notice to comply, to secure compliance with the statutes or regulations. Subsection 4, if there's no need to do additional inspections, no need to do complaint investigations, subsection 4 does say that at least once per year or annually, we will do a full inspection of the the medical marijuana establishment for compliance with health and sanitation. And then subsection 5, if there's information that suggests that there is a medical marijuana establishment operating without a registration certificate, that we will perform an inspection and investigation into that within 72 hours of being notified of that. And there are, as a side note, there are, inspection and other investigations operations within the division that are similar to this. This isn't new. This is, writing into the regulations, division procedures that have been successful for us and, are appropriate. Okay, so then skipping down into section 38, it talks about that when there are deficiencies or violations noted in the medical marijuana establishment inspection or investigation, the division will request a written plan of correction from the medical marijuana establishment, and we would ask that that be developed and provided to the division within 10 days so that we can approve that. If it's not acceptable, we'll let you know in writing, and you'll have to resubmit that corrective action plan. Section 39 talks about if there's renewal of establishment applications, that we will need to deny the renewal applications If we find certain things such as issues with the owner, officers, or board members being employees or contractors of the division, having ownership or financial investment interest in an independent testing laboratory, and so on. If there's false or misleading information provided to the division, or if during that, it comes to our attention that there's been a excluded felony offense, this is top of page 24, or if we get notification from a local government that the establishment has had its authorization to operate terminated, and you can read the other requirements there. Down to the bottom of page 24, still in section 39, those corrective action plans which I mentioned previously, they do need to be submitted to the division within 10 days after a report of deficiencies. Otherwise there could be disciplinary actions that we'll have to take against the establishment. Section 40, bottom of page 25, talks about agent card requirements. So it talks about the things that will need to be submitted in order for the establishment agents to get cards that are required by statutes. To obtain or to renew those cards, there'll have to be proper identification provided, the name and the identification number of the medical marijuana establishment the agent is associated with, an attestation form submitted. This is subsection 4, middle of page 26. An attestation form signed and dated by the person that the person has not been convicted of an excluded felony offense. That either the statement from that proposed agent that they do not currently hold a medical marijuana agent registration card, or if it's a renewal, the number of the person's current agent registration card. The agents will need to submit photographs to us, and then also fingerprinting will be necessary. And it is our intent at this point to, when these agent cards are developed, that they'll be printed and that the photograph of the agent would be included on that card. So moving into section 41, the division will issue 4 kinds of cards. It'll be medical marijuana establishment agent cards for independent testing laboratories, cultivation facilities, facilities that produce edible marijuana products or infused products, or medical marijuana dispensaries. The medical marijuana establishment, subsection 3, shall ensure that training is provided to the agents before they begin working or volunteering in the establishment. Training requirements include proper security measures and controls for that establishment, the prevention of diversion, theft, or loss of marijuana, procedures for responding to emergencies, state and federal statutes and regulations regarding confidentiality of the information related to the medical marijuana use. This is, of course, with the patients that are using the products. Going on to page 28, the instruction should include also the different strains of marijuana, the different methods of using marijuana, edible marijuana products, and medical and marijuana infused products. Also, the agents will need to be trained on recognizing the signs of medicine abuse or instability with the medical use of marijuana by patients. Section 5 or subsection 5 of this section, middle of page 28, talks about additional requirements for the laboratory agents, their training. It just indicates that they'll need to be trained on good laboratory practices, standard operating procedures for quality control and quality assurance. Subsection 6 speaks to the cultivation agent training, which will need training on the methods of cultivation used by that establishment, the methods of fertilization, the methods, top of page 29, methods for recognizing signs of insect infestation, pathogens, or disease in the plants, and how to eradicate them appropriately. Subsection D there, the nutritional requirements of the marijuana plants at various growth stages, proper mixing and dispersal of fertilizer, and the procedures for post-harvest trimming, drying, and curing, and safe handling of equipment, including the high-intensity bulbs that'll be, we expect will be used in the operations. So then we're on a subsection, the section 42, subsection 7 is a training on edible medicine or infused product training for the agents. They'll need additional training in the difference between topical products, edible marijuana products, and marijuana-infused products. They'll need to be trained on the procedures used by the facilities on the production of edible marijuana products or infused products, and how to handle those same products safely. And then, and I'll take a break there for questions. So any questions from those sections up through section 41 from Las Vegas? Feel free to come to the table. I have to push the button for the mic.
My question is regarding the training and educational aspects of the program. Is there a recognized standard or a training facility available in the state of Nevada that can provide this sort of certification in these areas? Or what is going to be the standard as far as how that training and education is obtained in order to have the knowledge to do this?
Thank you for your question. Could we get your name for the record?
Kimber Luciano, Luciano.
Thank you. There's not at this time a training center for these topics. We have drafted the regulations and we've looked at what's being done in other states. That's why we've specified in the regulations that the establishments do have some responsibility for developing the materials and providing the training to the agents and the appropriate training for each of the 4 different kinds of establishment agent cards.
Okay, and as far as is there like in accounting, there's the generally accepted principles and guidelines that are acceptable in all areas of accounting. Is there a set of principles or rules or guidelines so anybody could obtain an education through a variety of these different cannabis universities online? They could obtain their education and knowledge through there and be certified, and that would be acceptable?
There's not. We're doing our best to build this program, and we'll be, the information that's available online. I think you mentioned a cannabis university. We'll come up to speed on that and see if it's appropriate. But we don't have those standards in Nevada at this point. There's, as far as the laboratories, though, there are a lot of
laboratory testing.
Yeah, there's a lot of
Okay,
developed standards for laboratories that would be appropriate. And then there's also sanitation requirements for related facilities that operate in Nevada where there's training that would be appropriate as well.
This is Marla. It really is something that goes back to each individual applicant. If an individual applicant, say for example, a dispensary said, we're only going to hire individuals trained at Cannabis University, then that's their standard, and we would inspect to that. Well, you said you're going to hire everybody who's been trained at Cannabis University, and they meet the basic requirements laid out in the regulations, but now you have someone over here who isn't trained in that manner. So now you aren't consistent in your application. So it's going to be up to each establishment to identify what's acceptable training for staff that they hire, and to ensure that they follow through with those pieces. So we won't set up and say it's acceptable standard. They identify what's appropriate for their individual establishment.
But as far as issuing licenses for to dispensaries or to cultivators or to any sort of medical marijuana establishment, as far as the criteria for issuing a license for their experience in that area, there's no general standard. Any education that they would obtain would be acceptable as far as your criteria, meeting the criteria to be experienced in that field.
So when an applicant moves forward, the requirements for an applicant are specified in the regulations, and they have the obligation to identify how they meet certain components related to the applications. Then there are policies and procedures that establishments will have to adhere to. And what Chad was just discussing are the minimum expectations we have of your staff trained in your establishments. So how you intend to carry that out in addition is really up to each establishment, and we aren't saying what's acceptable or not acceptable in terms of education in any realm, whether it's applying as an establishment or educating the staff, but they have to meet the minimum requirements laid out in the regulations and the statutes.
And then whatever you identify to be your procedures in your actual business plan, you need to be consistent with following that through whoever is employed with you.
That's correct. Yes.
And my one more question has to do with the issuance of agents' cards versus a user's card. If a current medical marijuana user has a current card, how is that, can that be converted to an agent's card? And at what point will the agent's cards be able to be, applications be accepted to start the process to see whether or not you would actually qualify for an agent's card?
Okay, so I'll do my best to answer that. Let me know if I leave something off. So if, the current medical marijuana patient cards will not be converted to agent cards. They have different functions, different purposes. There will be, and they'll look completely different, and they're the statutes as well as the regulations identify them differently. We have a plan to have those agent cards developed, the applications and the ability to work with either print within the division or work with other state partners to have them printed well in time for the operations, the medical marijuana establishments to begin operations. And we're not ready to receive those applications yet, and we're still working on the details of how they will be printed. Did that cover all your questions?
We don't have to have our agent's card prior to submitting our application for a medical marijuana establishment.
No, nor will it be possible. So.
And if a current user is authorized to cultivate their own plants, and their current user, and they're applying for a business as a medical marijuana cultivation facility, will they be allowed to sell their stock to their facility once it receives its certification?
Yes, there's provision for that in the statutes and the regulation.
Okay, thank you.
Okay.
I'm Michael Betts with Third Day Creation. I just had a question regarding the agent registration cards hypothetically for an integrated, vertically integrated system where a dispensary, cultivation, production facility are all tied together, or even just, cultivation, production facility in the same building, still meeting all the zoning regulations and everything proposed by the state and the local ordinances. Essentially, anyone working in the cultivation would have to then also obtain a production registration card in order to just go next door or even pass through the building to the kitchen or production facility. And are you going to be able to issue multiple cards to any one individual, or is it, you can work in a cultivation facility, that's it, production facility, that's it, dispensary, that's it?
The statutes do require that there be different agent cards for the different establishments. We are actually exploring the possibility of having the ability to get an agent card for multiple operations. Again, all I can say at this point is we are exploring that, and we hope to be as helpful as possible on that with that topic.
This is Marla. We believe the intent of the law is to allow us to know who is authorized to be in an establishment at any given point in time. Although you might have a vertically integrated operation, the cards still allow us to collect separate card fees. So you could potentially work in those three areas of a vertically integrated business, but you would have to pay three separate fees for authorization to work in each of those three aspects of the operation. And then, as Mr. Westham said, we are striving to issue one card that authorizes you to work, and that when we verify it, it says, yep, you're authorized to work here, here, and here. What we will not be doing, and we've made this clarification before, is issue a card to an agent and that agent be allowed to say, look, I'm approved to work in any dispensary. Here's my card. That's not acceptable at all under the law.
Okay, thank you.
Hi, good afternoon. Warren Markowitz, CBD Partners. I have two questions, if I may. One has to do with the audit requirement under Section 36, Paragraph 3. There's been no time frame provided for the completion of an audit, even though it says in Section 2 that a financial statement is to be provided upon the application, the renewal application process. Is there a time frame that's been thought of for compliance with the audit requirement in Section 3?
Time frame, and I think I mentioned it as I was going through those sections, would be that information needs to be submitted with the renewal, and that it would be for the time period that your establishment was operating. So,
But technically, I wouldn't be able to comply with a certified audit until after my close of business for that particular year.
Correct. So
I can provide a financial statement. Most accounting programs and most accountants can provide me the year-end financial statement, but a year-end audit is going to take a little bit more time than simply pushing a button.
we don't have a date of when those renewal periods would be anyway. Yeah, it's for the previous year.
So are the renewal periods going to run on a calendar basis or on a licensing basis then?
There'll be
Or is this something
the
that
renewal
needs to be
periods will
determined?
be consistent, with the 10-day period that's specified in the statutes, and it'll happen once per year, and we don't have the dates yet.
Okay, so to clarify then, an operation that currently has a certificate will be able to continue to operate during the renewal period.
So the audit requirement is for the previous year or portion of the year in which the establishment was operating. The renewal period will be based on when we actually issue your certificate, your final certificate. So a year later is when it would be renewed.
I understand that, but what I'm asking is during that renewal period, when I have the opportunity to submit my application, I'm obviously going to have a window. It's during that window in which my audit is going to be provided to you. So I'll be able to continue to operate while the renewal is being processed.
That's
Is that
correct. You will be able to continue to operate while we're processing your renewal. There will be provisions for deadlines for renewal and those things, but the operations continue until such time as we actually move forward to revoke based on if somebody didn't renew, whatever reason we might have at that time. But yes, you continue to renew and continue to operate. You don't have to cease operations while you're going through the renewal process.
Okay, thank you. And next question is under Section 37, involving a reasonable inspection by the division. Is there going to be requirements in the division's policies to comply with sanitary and safety conditions in a facility, such as in a production facility or in a cultivation facility? Are they going to be required to comply with those safety and sanitary standards?
Yes, absolutely. They're actually specified in the regulations. We won't be getting to the details of that today, but the next stakeholder session will be going over the details of that.
Thank you very much for your time.
Yeah, thank you. On the phone, was there questions on the sections we've gone over here? All right. Just one moment. Any questions in Carson City on those sections here? Sorry, I got ahead of myself.
Just one question. This is Shane Johnson again. In Section 40, speaking of the obtaining and renewing an MME agent registration card, there's an exception, obviously, for a consultant who performs professional services for an establishment. Does consultant, in your view, in this case, include people like plumbers, electricians, contractors from an outside party who would be coming in to perform a specific task, but not actually working in the MME?
I believe, can you give me that subsection again? But
It's Section 40, the top paragraph.
Okay.
There's basically an exception to the requirement to obtain
Yeah.
an agent card for a consultant, and I just see obviously the need for electricians, plumbers,
Right.
people dealing with the electronic surveillance systems, et cetera, to come in, obviously be accompanied by an agent, based on other specifications in the
Right.
provisions, but.
Correct, and they would need to be issued a visitor's badge.
Okay.
And that was our intent.
But they would then, in this case, fall under a consultant, in your view? I just wanted to clarify that that's envisioned here as opposed to that we would need to get them issued an agent card.
That's my understanding.
Okay.
And it really, we make that determination at the point of inspection. Okay, look, you've called this person a consultant, but they're here every day. But they're here on a routine basis to do something all the time. They're an agent. So it's on some level going to be case by case.
If they're there on a routine basis, it would be in our best interest not to have to accompany them, so understood. Thank you.
Adam Mintz, Steeple Hayland. On 41, sorry, lost it. Section 6D, it references the drying and curing procedures. There are numerous cannabis patients that use the raw cannabis plant before it is dried and cured in order to juice it, and has an abundance of THCA. And that's just a practice that a lot of patients do. They juice the raw cannabis. So will this drying and curing procedures section here preclude anybody from using fresh cannabis for juicing?
No, this section's talking about the training that's expected of the agents, and it gives examples of things that they need to be trained on. It's not prohibitive on what kind of products might be possible.
Thanks.
So the training would say, don't dry the product.
Okay, so we'll be moving on then in the sections. I think we were on 42. So we'll, after we break, you can bring your questions. I'm going to move a little quickly and, all right, so 42, renewing or changing an agent card. An applicant submitting an application for a medical marijuana agent registration card shall submit the application electronically in the format prescribed by the division. That is a process that we're working on currently. It's not available yet, in case you have a question. Section 43, this talks about if a person has an establishment agent card and needs to make changes. It talks about how to go about that with the division and what the information will be needed, such as change of address, change of the name of the card holder, if the card needs to be replaced. Going on to page 31 here, section 45 is the agent registration card. If we do have to replace it, the new card will have the same expiration date as the previous. Section 46, the division will provide written notice to an establishment agent that his or her agent card is no longer valid when the person is, we receive notification that the person is no longer serves as an owner, officer, or board member, is no longer employed or contracted with the establishment, no longer volunteering at the establishment. And, it does say the very last section, subsection 2, that it is not considered a final decision of the division and is subject to administrative review. Moving into section 47, as far as the agent card denial and revocation, there'll be a need to consider denial or revocation in the situations listed in this section, such as felonies that we've become aware of that a person's been convicted of. If there's been, documented violation of the provisions of the statutes or this regulation. But that'll all be provided in writing to the agent. So moving into section 48, basically outlines that, if there's violations of these sections of the regulations, those are grounds for disciplinary action by the division, including revocation of establishment registration certificates, as well as the agent cards of those that were involved. Section 49 is a different topic. Talks about the fees to be charged to the establishments. And that's listed on page 34. I don't need to read these to you. There's an initial fee, as you know, of $5,000 for the application. For the dispensaries, there's a larger fee of $30,000 once the registration certificates have been issued. There's other fees, lesser fees for the registration certificates for cultivation facilities or laboratories or production facilities. Those are all listed out. And then into subsection 2, it's worth noting that the entire program is designed to be a fee program, that the fee to have the medical marijuana establishments and their certification and the inspections and the investigations and the renewals and all the work and staff. It's covered by fees that we charge. There's not gonna be a state general fund moving forward long term. So this section, subsection 2, top of page 35, just indicates that there'll be an assessment fee for each establishment corresponding to the time and effort for the staff to oversee the establishment, and it'll be based on an hourly rate for each inspector or auditor as determined by the budget of the division. And if it's any, for what it's worth, we do this in other programs. We have solid systems to where it's quite fair and equitable, and you know exactly what fees are being charged to you and why. And we'll be mirroring that with this program as well. Section 50 just indicates that you'll need to post your establishment registration certificate and business licenses and other related documents conspicuously. Section 51 does talk about that the establishment does need to get approval from the administrator of the division for both their name and logo that they'd like to use on their establishment, as well as their signage and advertising, and that you aren't, the establishments are not to use such documents that have not been approved. We'll be establishing procedures for that process. Section 52, and we've had some questions on this so far. So says that the establishment shall not sell a lot of usable marijuana or edible products or infused products until all required quality assurance testing has been completed. The persons who can be on, section 53, bottom of page 35, the persons who are authorized to be on the premises of a medical marijuana establishment are an establishment agent, a patient who holds a valid ID card, the designated primary caregiver of a patient, a person inspecting the establishment pursuant to this regulation, or anyone else who's authorized on the premises who obtains a visitor identification badge. And actually, this is what we were talked about before. The person going in subsection 3, outside vendors or contractors will need a visitor ID badge, and they do need to be escorted and monitored by an establishment agent. Excuse me. Okay, so subsection 5 of section 53, top of page 37, says that if there's regular employees or seasonal or temporary employees or even volunteers at an establishment, they do need to get medical marijuana establishment registration cards. Section 54 outlines that the establishment does need to develop policies and procedures on a variety of topics that would be typical with most businesses: job descriptions and employment contracts, duties, authority, responsibility and qualifications of personnel, supervision of personnel, their training, especially as it relates to confidentiality, evaluations of employees, disciplinary actions, business records. Then we get into the section 54(1)(c), talks about inventory control. So this is policies and procedures for inventory control. Accepting marijuana from patients who hold valid ID cards and their caregivers. And the policies will be needed on records of the patients who hold the cards, such as, when those purchases were made from them, if there was denial of sale, delivery options, and so on. This is to make sure that, the product is tracked very clearly and and not diverted. There'll be policies and procedures needed for patient education and support. This is that subsection E of page 38. And there's a prohibition on smoking, policies and procedures on prohibition of smoking of marijuana in public places, places open to the public, or places exposed to public view. So section 55, page 38, talks about that the medical marijuana establishment agent card does need to be in possession while a person is employed or volunteering at the establishment, while they're transporting any products, while serving as an officer or board member. And then moving on to subsection 4 of section 55, the division does need to be notified within 10 days when an owner, officer, or board member ceases to serve in that capacity. Right, section 56, bottom of page 39, before dispensing, I'm sorry. Okay, so before a medical marijuana establishment agent dispenses product to, a patient, they will need to do a number of things: verify the identity of the holder of that registration card. They need to offer appropriate patient education and support materials, verify the validity of that card or the card of the designated caregiver, verify that the amount that the patient or cardholder is getting does not exceed more than 2.5 ounces of medical marijuana during any 14-day period as required by the statutes. That information will need to be entered into an electronic verification system: name, amount, whether the person was a patient or a caregiver. I'm on page 40 here. The date and time at which it occurred, the number of their establishment registration certificate where this sale or transaction is occurring. Section 57 gets into the requirements for an inventory control system at the establishments. Each establishment will need to have a single person who is designated as the agent with oversight of the inventory control system. This regulation states that the establishment shall only acquire medical marijuana or products or infused products from another medical marijuana establishment. And then the exception is that a dispensary may purchase marijuana from another medical marijuana dispensary or from a person, and this is subsection B here, page 41, that a person who holds a valid ID card or their caregiver. So subsection 3 on page 41 there just outlines the requirement for implementing an inventory control system, which will include each day's beginning inventory, acquisitions, harvest, sales, disbursements, disposal of unusable marijuana, and the ending inventory. When acquiring medical marijuana from someone who's a medical marijuana patient or caregiver, the amount and strain as specified by the cardholder or caregiver if known. And it lists there as you go on through the section, the things that need to be recorded, such as the date and the person, the identification number of the establishment or the certified establishment. This section is quite lengthy, but, starting in subsection 5, page 42, talks about the inventory control at cultivators, including batch numbers, whether the batch originated from marijuana seeds or from cuttings, the strain of the seeds or cuttings planted, the date, a list of the chemical additives used in cultivation, including without limitation non-organic pesticides, herbicides, and fertilizers, number of marijuana plants grown to maturity, final yield, the agent card number of the person responsible for the harvest, and so on. So then going on to the bottom of page 43, so when the establishment is selling or providing to other establishments, it lists the things that need to be recorded at that time, some of the same things that we've gone over in other sections. Top of page 44, subsection F, talks about the same information that'll be needed to be recorded when receiving edible marijuana products from another establishment. Subsection G, subsection G talks about the receiving marijuana infused products from another marijuana establishment, the recording of the same inventory information. Not any unique requirements there that I can see. And so then towards the bottom of this section, on bottom of page 45, subsection 4, each medical marijuana establishment shall establish and maintain a perpetual inventory system which adequately documents the flow of materials through the manufacturing process. It will have procedures which reconcile the raw materials used to the finished product on the basis of each job. Significant variances in those processes will need to be documented and investigated by management. And if there are such variances, those do need to be reported to the division. There'll need to be, there's a subsection C there, provide for quarterly physical inventory counts by persons independent of the manufacturing process, and those are reconciled. And if there's variances, those will need to be documented, investigated, and also reported to the division. And that brings us towards the end of section 57, and I'll pause for questions. So we'll, when we first go to Carson City, if you've got questions on these sections we just gave a quick overview of, please come to the table. Anyone Carson City? Okay, please come up. Just if you could please share your name.
My name is Ed Alexander, and I have several questions. The first of which is section 51. Do you envision establishing a reasonable time frame for the quality assurance testing, as it states that we cannot dispense product until the quality assurance testing has been completed?
Well, I believe this section does refer to the use of the certified laboratories that the division will be certifying, and that those, the laboratories will be up and operating, and then they'll be able to do the testing of the product before it's distributed.
My question being, with some of the fine detail that you're painting the regulations, I don't see anything that specifically calls out for those testing facilities what their time frame is to provide a quality assurance test, if you will.
I understand your question. It's the response time.
Correct.
In the laboratory requirements, that's not specified now.
I just think if there's potentially, let's say, one Northern Nevada lab, and we've got 10 Northern Nevada facilities and a myriad of Northern Nevada cultivators, the potential for inundating that lab and potentially being, weeks potentially before you've got a quality assurance, that's going to be unacceptable business practices from a dispensary's point
Sure.
of view, I would assume.
Well, part of our hope in some of the concepts as we developed the regulations and the program is that the principles of free market will prevail, and if there is a need identified, by the industry, and there's not enough laboratory analysis, not enough capacity, that that there'll be entities that see the business opportunity and will that'll increase to meet the demand.
Okay. Next question pertains to section 54, as it clearly calls out that all non-organic products will be listed. Am I to assume that any organic fertilization used in the production of marijuana does not have to be listed?
I did think about that as I was reviewing these. I will need, because there's another section, I think it's further on, where it does specify agent or entities that do certify organic products. So I need to reconcile what that says and what this says and make sure that we haven't created a problem. I'll try to make sure that the regulations are clear. I mean, in short, we'll need to review the products being used on the marijuana, whether they're inorganic or organic.
Okay.
And we'll do what we can to make sure that's clear.
Okay. Section 56 talks about electronic verification methods. My question is, in the event of, as Colorado's just experienced, their system crashing on day number 1, what provisions do you envision for non-electronic verification? Or in the event that the state-sponsored website goes down, do we effectively close all of these businesses for the day, or whatever period this electronic verification method is not up and running?
Good question. We hope that there'll be enough levels of redundancy to where that's not something that we're going to have to explore. All I can say at this point is that we've had discussions that if something like that did happen, that the establishments would have their portion of the inventory control and verification system, and that they would, might be able to verify some of it with their local systems. But we're doing our best to where that won't, there'll be enough redundancy and that won't be necessary.
And part of that redundancy is the responsibility of the establishments, to track and document what you're doing. And in addition, cardholders have the legal obligation to only purchase what they need to purchase. So if something like that happens and we move forward with a contingency and they dispensary hopped, they need to understand that there could be consequences to their cardholder
Status.
privilege at that point.
Yeah, I guess my point was if the system went down and we had a redundant system in place to where we were going to document, handwritten document all of the information and then enter it upon the system coming live, would that be an acceptable practice in the state size?
I hope, I
Yeah,
hope
I
we don't
mean,
have to get to that point.
right.
And
Yeah.
But we would issue guidance and be clear about it, and we will have those plans in place.
So that is something that you intend upon having a provisional plan in place prior to the process moving forward.
Yes, but what we're working through right now is that we're looking at which systems we'll be making use of, and the software to be involved in the programming and the servers and the backup servers and redundancy. So we're working through that right now. So we're just not at a point to address the contingencies, but that is part of the process.
Thank you.
And just for clarity, looks like I made it quite a ways on my last discussion of the regulations. So if you have questions through section 62, and you're coming to the table, that we can go ahead and accept those questions at this time.
Attorney John Geslin, Under section 53, entry to establishment is limited to 4 separate categories, one of which is a person who holds an agent registration card. And then under section 55, in order to be an officer or a board member of an establishment, you have to have an agent registration card. Does that requirement extend to the owners also? So does every owner,
Yes.
in order to get on his own, into his own establishment, have to obtain an agent registration card?
Yes, that's how this reads.
Is that clear? Okay.
Yeah.
That's my question. Thank you.
Megan Salcido from the City of Reno. Thank you again for all your hard work and for allowing us the opportunity to ask questions and get clarification. My question relates to section 53, and I guess a few other sections throughout relating to the authority of local government officials to be on the premises of facilities without visitor cards. So if I'm looking at section 53, it would probably fall under D, a person inspecting the establishment pursuant to section 33 or 37. Looking at section 33, it specifies the division may at any time be located on the facilities premises, and then in subsection 4 makes reference to public safety inspections required by state and local jurisdictions. So I'm assuming that that reference authorizes their presence on the premises without a visitor card, and if not, is that something that you envision local governments incorporating into their own processes to give that authorization to be on the premises without a visitor card?
I believe the intent was that the person needing to inspect the establishment, the intent was that they would include local government inspections. And I don't believe this language suggests otherwise.
Okay, and then if we look at section 37, that makes reference to complaints that are received, and that gives the division the authority to investigate those complaints and conduct inspections as necessary. But I don't see any authority for local governments to conduct any inspections with regard to complaints that are received. And if that's something that locals need to contemplate in their own process, then that clarification would be appreciated.
I mean, that, I guess where this section 37 is written with the division in mind and the establishment requirements as in these regulations and the statutes, you know, they're, the local requirements, like if there was possibly a public health nuisance being created by the establishment, you know, the local government would need their own, you know, requirements and guidelines on how to go about that. I mean, you do have your local ordinances that would apply, you know, or if there's any, you know, solid waste issues or something else.
Okay,
Sure.
thank you.
Yeah, I think in the public workshop and after that, we made a decision that we wouldn't write in anything that a local government already has their own authority to enact. So yes, if they want it, you need to specify it in your local ordinance.
Thank you.
Sorry, I had one question as it related to the inspectors.
Sure.
Will the inspectors be subject to the facility's best practices? In other words, if an inspector enters a cultivation facility and we have a clean room business practice in place, will, as a business owner, will we be able to enforce our business practices before that inspector is allowed to essentially inspect the facility?
Can you give an example?
I would hate to have a inspector that just went into a cultivation facility at 9 o'clock in the morning, drag some bugs or some mites or something of that nature into a facility that he inspected at noon, essentially having a catastrophic effect on that cultivation facility. So
the inspectors and auditors, the people who will be entering your facility will be it'll be very appropriate and trained individuals, and I don't know if enforce is the proper word that you'd be able to enforce, but
request.
You'll find that they are that they'll comply with your requests and they'll have no interest in doing anything to compromise your product or your procedures.
Okay.
Yeah, and so I guess if, as far as decontamination processes that you'd use and in your clean rooms and stuff, if, you had, it depends on if you're talking about a production or cultivation or dispensary, but if you had requirements for, gloves or hair restraint or even, maybe let's say laboratory coats, the inspectors would, put those on just like your staff would to protect your product.
Okay.
Yeah.
Thank you.
Hi, my name is Margot, and I have a question regarding the disposal of unused marijuana and what your criteria. Is there anything that guidelines for that you've established that's going to be what you're expecting us to do with it?
I think the next stakeholder session we'll talk about the disposal sections a little more detail, but it'll all be part of your inventory control. It'll be able to need to be tracked.
Sure.
And it does say in the regulations that it has to be rendered not usable. Some facilities that we're familiar with in other parts of the country do, render it not usable by pouring, chlorine, bleach on the
Okay.
product. But then as far as how they're disposed of, it'll be subject to local ordinances if appropriate, whether, they're disposed of in a manner that's to a landfill or recycled or whatever. It's going to be subject to local ordinances.
Okay. And then on the testing,
Okay, and state and federal law as well.
okay, all right, sorry. Is there, when we take it to be tested, what is the quantity that they're going to require, and any idea of fee, and do we get it back?
At the next stakeholder session, that the
Okay, I'm
laboratory
ahead of myself
requirements will
then.
be, let's just keep those questions for our
Okay.
next visit.
And then going back to the electronic verification, this is probably ahead of it too, is it going to be set up for out of state so that we will be able to verify, because it's been said that you will be able to accept out of state card holder med cards. Will that be set up so that we're integrated with out of state like California, since we're neighboring?
In concept, that would be outstanding if that could be set up, but at this point, initially, we do not foresee that all the states that allow medical marijuana will have a electronic system that we can connect with, tap into. So there'll be other procedures that are set in place for the reciprocity of patients coming in from other states
Okay.
to make it happen. Marla has a comment on that.
The provisions related to electronic verification for non-resident cardholders, in 2016, it changes to say that if the other state doesn't have a means of electronic verification, then we will not honor that non-resident card. So right now, that's how the law reads, unless it's changed in 2015. So other states would have the obligation to have some form of verification, and if they didn't, then those non-resident cardholders wouldn't be eligible to purchase.
Right, well, like California does, so you guys would figure out another way of...
No, we wouldn't figure out another way. If there's no electronic verification system in that other state,
Okay.
then right now, the law does not require us to serve non-residents. But that goes into effect in 2016.
Okay, and then my last one was, and this is probably ahead too, is how you guys are going to assign to each dispensary the patients initially. Because it was been,
We
it
will
was
not be assigning patients to
to certain
establishments.
dispensaries. I thought it was my understanding that you guys were going to, that they were going to be appointed, and then they could make a change within 30 days?
They can choose which
They could choose,
dispensary
but then they
would-
can only change after 30 days?
Correct. They can choose, and they can actually have the option of having that choice posted on their medical
Okay.
marijuana patient card.
Okay.
But they aren't restricted. The law does not restrict them to only buy from that dispensary that they choose. So it's just
Oh.
one of those weird nuances of the law. A patient can declare one, but they
They don't have
aren't
to stay-
required to only buy at that dispensary.
Oh, not for a period of time? Okay, not for 30 days or?
No. I
Okay.
mean, you're right, they can change after 30 days, but the
Okay.
law doesn't say you sign up for a dispensary and that's the only place that you can buy it.
Okay, I guess I misread that then. Thank you.
Thank you.
Yeah, Walter Marting, again, apologize for belaboring this, but under 40, we talked earlier about contractors being exempt from having an agent card. Under 55, we talk about they must have, if you're an officer, a board member, or someone have a contract to provide services needing a card. Is there some distinction here I'm missing, or is this something that's going to be cleared up as we go along here?
Board members and owners need cards.
Board members, or if you want to be employed by or have a contract to provide services to, it's a contract to provide services to that seems to contradict what's said under 40, where your contract, you're exempt from that. I mean, is there clarification coming on that?
It's a consultant for professional services is exempt, not a contractor for
Okay.
the establishment.
Consultant
So
for
that's the
profession versus a
distinction.
contractor for
Right.
services. All right, thank you.
So that's for Carson City. Las Vegas, if you could hold for just a minute, let's take questions through section 62 from the phone. Anyone on the phone with questions? Okay, hearing none.
Yes, Jeff.
Oh, go ahead.
No, you go ahead. It's okay.
Any questions from the phone?
Yes, I'm sorry. Jeff Harrison again. Thank you very much.
Okay.
It's probably going to hopefully be answered pretty easily. You referenced section 49 a little earlier, and I wanted to just get clarification. If we are putting in an application for both a dispensary and a grow, are we submitting two separate applications and/or are we submitting two separate fees?
Yes. Separate applications and separate fees as outlined in that section 49.
Alrighty. Thank you for the clarification.
Thank you. Anyone else on the phone, if you want to state your name and your question, please? Okay, hearing none. Las Vegas, questions?
Yes, John Sandy again. Thank you very much for recognizing me a second time. I do appreciate it. Just a couple quick questions. One, it's not really addressed in the regulations, but I think it's appropriate after listening to all the types of materials that are going to be required as part of the application. I believe it's 453A 700 mentions the confidentiality of applications and documents. I was just wondering if you thought excuse me, if there are confidential trade secrets that are contained within those, is the entire application itself going to be confidential, or should applicants redact those portions? Or I was just curious how that would work out.
The applications will be, portions of them will be considered confidential. I don't see a need to redact information. We'll need to review the material on your application to see if it'd be appropriate for what you're applying for.
I guess I misspoke. I should submit a portion of our application under seal so that the division can obviously go through them and review the contents of those. But I'm just curious if you're going to put all the application on the website, if we have to worry about any of the confidential trade secrets that might be contained in those documents.
So we don't intend to post the applications on the website. What we intend to post in terms of going out into the future is the dispensary name, location, contact information, so where someone can go and buy the product they need. We actually will not disclose on our website cultivation addresses or production facility addresses or lab addresses and contact information. But, and then we have an obligation to ensure that, yes, if there are trade secrets, that somebody doesn't make a public records request for them and be able to receive them. So we intended that our regulations identify those records that we could keep confidential. If there's still some gray area in there, if you could comment about where you feel like there might be some potential for information to get released, because our intent was to not allow certain pieces of information that should be kept confidential to be released. So hopefully the way that it's structured, it did that adequately, but if it didn't, then we would ask for you to give us some more specific information in that regard.
Great, I definitely appreciate that. The next question I have, and I kind of expected a few questions on it, but Section 51, what is exactly the scope of the division's review of advertising material? I was mentioned in the 23rd hearing. People were asking, does this mean that we have to get, if we want to tweet something out or put something on social media, do we have to get approval from the division first, or is this really just the logos and the content of the logos that we're going to be using to display our businesses?
There's, as written, we'll need to review the names and the logos. Then in Section 2, or subsection 2 of 51 talks about the signs and advertisements being approved by the administrator of the division. That's actually still being developed, what we're going to be looking for. We're talking with the Secretary of State as far as some of their requirements as you register a business. I guess conceptually, if you have examples of advertising that you would like to use and that you could provide them to the division so that we could approve them, and then if you put out some sort of message on social media that's very much or exactly like what you've already had approved, that would seem to be acceptable. As long as, and then if you want to do something, you want to deviate and do a whole new media campaign, and you're going to change your logo, change your message, then we would need to review that in advance. Does that help?
It definitely does. So I'm going to just ask the question, I guess, this way. So, like, for example, and I'm just coming off the fly, if an establishment wanted to offer a sale to military veterans that you get half off, and would we need to get that content, the sale itself, approved by the division? As long as we don't change our logo and what we're putting out on Facebook with it, is that an advertisement that would require approval from the division, or is that, I guess, kind of a complimentary advertisement under our already approved advertisement logos?
Mr. Sandy, regulations have not been adopted yet. We'll be working through that, and I can't give you a specific answer on that at this time.
No problem.
Okay.
No problem. I appreciate that. And this was kind of addressed already, Section 56, and hopefully this is just a technical change that could be made, or if you deem it necessary. This section, as I read it, tells you who you can dispense your medical marijuana to. And I think that in light of NRS 453A 364, and moving forward in 2016 when states that allow for verification, we need to include the non-resident cards that are approved under that section for that, because it just doesn't, the section doesn't contemplate it as it's written, just for your suggested technical amendment.
Thank you. Well, thank you for that suggestion.
And then I did have another question, and I don't know if Chuck's still here or not, because I should have run it by him first, and I definitely don't have a problem with it. I was just curious, under Section 58, 3 sub B, it requires confirmation, a log, which must be available for inspection by appropriate law enforcement agency. And again, I have no problem with it, but I was looking under the statutes 453A 700 that records to law enforcement, I think they can only be provided for the purpose of establishing whether a person is a card holder, and that these records that we're going to be keeping, these logs of them, are going to have a lot more information on it than that. So I just wanted to know, or just make you aware of it. I don't have any preference either way, and don't have any problem advising people to make those inspections available to law enforcement. It just seemed kind of or I guess maybe somewhat of a conflict.
Can you give me that section number again?
Yes, I'm sorry. It was section 58, 3, sub 3, sub B. At the very bottom of the page on 47.
Yeah, I see it. Okay. Yeah, we'll review that. Thank you for bringing that to our attention.
Absolutely. I believe that was all the questions I had at this point, so thank you very much for your time.
Thank you.
Hi, Karen Becker. I have just a technical clarification point on section 53, subsection 2. The language as it reads now says that the agent has to get the visitor badge before entering the premises. I'd like to see that changed to upon entering, because if you make them do it before, it really means you have to set up a procedure for having someone talk to you the day before, maybe sending by email the badge the day before, or you have to meet them out in the parking lot.
So that's section 53-2. Let's take a look at that real quick. I mean, we have seen establishments in other states where they've got kind of like an entrance area, foyer, which is basically before the majority of their establishment, where things like that could be handled, but
Well,
I see.
I mean, I kind of anticipated that this would be done like at the lobby, the same place that you would verify a patient who walks in. If that's not the intention, I'd like a little clarification.
Well, the intent is that they would obtain the visitor information badge before entering the premises. Yeah, we might need to clarify what the premises are to make sure that we're not stating something that's unreasonable. But the intent is not that you have a meeting the day before, that you meet in the parking lot, but that have the appropriate visitor ID badge before you tour or go through the facility. So thank you, and we'll take a look at that possible
Thank you.
clarification on premises.
Thank you.
Any other questions in Las Vegas through section 62? All right, thank you. Looks like we're to the next agenda item. Marla, I'll turn it back over to you. Public comment.
So before we get into general public comment, I did want to say that we've received some communication again, or asking for revisions to the Nevada revised statutes. I just want to remind everyone that we aren't in a position at this point to make any changes to the Nevada revised statutes, but I will, for purposes of the next agenda, put some of the items on for discussion that relate to implementation for us on the next agenda. Well, actually, we already have the agenda out, so we may need to hold another meeting unless I can deal with it some other way, to kind of talk about some of the issues that have been brought up that do relate to implementation. But there was a question about the separation. Let me see if I can get this. Separate buildings. We did issue clarification about that back in January, the end of January, through our listserv. So you might want to check that again to make sure that you understand what that guidance was. But again, we'll look for an opportunity, maybe just written out through the listserv, to respond to some of the other issues that came up that aren't addressed on this agenda or the next agenda. So we'll go to general public comment. Anybody have anything general? I'm not seeing, oh, go ahead, come on up.
I'm not sure if this is applicable to general public comment, but I just really need to bring up section 131, if that is appropriate for general public comment. Okay.
It's February 24th, 10 a.m.
Okay, anybody on the phone? Well, thank you, everybody. We appreciate all of your help. It's been very useful for us as we continue to move through the process, and we'll do this again on Monday. Thank you.
I can still see you. Can I come home now?